Hello, my name is Andrew Nyamayaro, a solicitor at Tanlo Solicitors, based in Coventry, United Kingdom. I am a lawyer who specializes in different areas of law, and the firm that I work for, Tanlo Solicitors, also does law in different areas. So in our practice, we do immigration, which is both business immigration and personal immigration. We also do family, where we represent individuals in cases involving matrimonial issues such as divorce, separation, financial, and child arrangement orders. There's other things that you can deal with under family law. We also do wills. We help people to draft their wills, and we deal with probate. Probate is known in other countries as succession, but it involves the administration and the management of the estate of the deceased person. We are also into business and commercial transactions. We advise businesses in transactions. We draft commercial documents. We also advise in compliance, regulatory work, and so forth. So if you've got anything that requires advice in those areas of law, Tanlo Solicitors is your go-to place, and we will be able to help you. Today I'm making a presentation on immigration updates. So the major update that is taking place is actually taking place tomorrow. Today being the 24th of February 2026, and tomorrow being the 25th of February 2026. The change is that the Home Office is implemented what is called an Electronic Travel Authority, or an ETA. So an ETA, Electronic Travel Authorization, is permission that is granted to people that are normally not under a visa requirement. I have heard a lot of inquiries from people that are British, people that have got a dual nationality, and people that have got visas under other modes of immigration who are concerned about this. So let me just talk about this into detail. If you are a British citizen and you are traveling on your British passport, going out of the country and coming back into the country based on your British passport, you do not need an ETA. If you have got another type of visa, you might be on refugee status, or you might be traveling on a traveling document, or you are on a skilled worker visa, you are a dependent, you have got settlement one way or the other, you are a student, and or an EU nationality, then you do not need an ETA. You require an ETA if you are going to travel on a passport. Normally that passport being of a person that is on a non-visa, from a non-visa country. As you will be aware, some people can come into the United Kingdom for less than 6 months without the requirement of a visa. So they can just come on their passport, and for example, people that are coming from EU, they don't need to apply for a visa. Some countries as well, they do not need to apply for a visa if their visit is up to 6 months or less than 6 months. All they need to do is just buy their air ticket and then come through the port of entry, and then if they are leaving, go through the port of exit, and then they will leave the country. But with effect from tomorrow, you will be required to get an ETA, an electronic travel authorization. This is not a visa. This is not a requirement for a visa, but it's just accountability that the Home Office said they need. So for you to have an electronic travel authorization, you need to make the application online. You make the application online, and you pay a payment fee of £16. The ETA is valid for the life of your passport, the passport that you have. You pay your £16, that's it, and then it will be valid for the validity of your passport. So if you are, again, for example, a dual nationality, you've got a British passport and you've got another nationality of another country, if you are traveling on the British passport, there's no issue. If you are traveling based on your other nationality, so if you have a nationality of country A, which is not the United Kingdom, then in that case, if that country is on a non-visa scheme, then you will need to apply for your ETA. Otherwise, you risk not coming back to the United Kingdom. Let me give you a practical example. You could be a British citizen that is domiciled and resident in Spain. So you are staying in Spain and your British passport is expired, you are still in Spain. Because in the past, you could come to the UK for less than 6 months and go back on a Spanish passport. You are not really bothered about renewing your British passport. In this instance, you are just relying on your Spanish passport. So you will need to get an ETA because you're relying on that passport. Otherwise, you may not be able to enter the United Kingdom if you're going to come back based on that particular passport or on that particular ETA. I beg your pardon, that particular passport without an ETA. So just make sure that you have complied with the law. Otherwise, you will be embarrassed at the port of entry when you're not allowed to enter, or you will be highly inconvenienced when you will not be allowed to enter and you're coming for whatever reason that you're coming to the United Kingdom. So that is the issue relating to the ETA. If you're not so sure on what to do, how to do it, and so forth, Tanlo Solicitors is there to help you. You can contact us and our team, and we'll be able to assist you with all the processes from the application of the ETA up to any other advice that you might require for the ETA. Things get complicated, for example, with if it's a family, for example, some of the family members have got British passports, some don't have British passports, they're on coming from a country which is a non-visa country, and some of them will have to come on the 6 months and so forth. So in those circumstances, then other part of the family members might need to have the ETA, when others might not need to have the ETA. Again, you have to evaluate your circumstances and your situation to see whether or not you will require an ETA. The next point that I need to address is the point of citizenship. Now, of late, because of the suitability requirements, a number of people have been refused their applications for naturalization. Naturalization is the process whereby a non-British person makes an application to become a British, or to obtain the citizenship of becoming a British. So, because of the suitability requirements that were made by the Home Office last year, 2025, it is now more stringent and more stricter for you to get citizenship. And for those reasons, a number of people are getting refusals. So, for example, if you've got a criminal offense, if you've got a CCJ against you, if you entered the United Kingdom illegally, those are some of the reasons that the Home Office is looking into account. Or any breach of immigration rules, some of the reasons would be you invited someone to the United Kingdom, they never got back, or you're staying with someone who doesn't have a leave to remain, and any other reason that could be there, then they are refusing you citizenship. We have been dealing with quite a number of such cases where people have been refused. And if it's a family, maybe it's the parents that have been refused citizenship. but the children have been given citizenship, because at the time of entry, if it was illegal entry, surely you can't blame the children. They didn't know what was happening. So the Home Office tends to be lenient when it comes to children in those circumstances, but then denying the parents or any person who is allegedly breached the Home Office requirements. It is important to note that there is a case, or there are cases that are ongoing, which will be treated as test cases to challenging the Home Office on the citizenship requirements as of 2025 and its refusal rate that is there. So the Home Office has put on hold a number of applications where they have identified certain possible breaches, and they cannot make a decision until the test cases has been heard by the courts. So you might experience some delay with your citizenship application, or some request for further additional information from the Home Office when you've made a decision, an application for citizenship. So I would rather maybe you wait until the Home Office has made the court has made a decision rather than the Home Office. But if your case is straightforward, then you can make your application for citizenship. The difficulty of the situation that we find ourselves is that the laws are changing, and we are aware of the white paper. The white paper is even going to make it more difficult again to get citizenship. There's a proposal to make the English test more stricter. And life in the UK is going to be changed again to make it more difficult. And the period of settlement might be increased as well. So it's a case of, what am I going to do now? Should I make an application for citizenship? Should I wait for the case that is in the court to go ahead? And what do I do? That's where you need legal advice for people who are in the legal sector, so that they'll be able to help you to make that decision. Because if you make a citizenship application and it has got no prospects of success, you are going to lose your fees. You're going to lose your money, your time, the money that you pay to the lawyer, the money paid to the Home Office, and so forth. And again, if you delay unnecessarily, you might then get into the time where the Home Office is going to change the law, making it more difficult for you to get your citizenship. So anyone who has had their citizenship application refused, or say in the last 12 months, you can contact us so that we can review your case. And if need be, we have to make a reconsideration application with the Home Office to challenge them of their decision. The next issue that I want to point on is the fee waiver. Fee waiver, fee waiver, fee waiver. And this has caused a lot of confusion for a lot of people, particularly people that are on a skilled worker visa, who are facing curtailment, whose employers have had their sponsor licenses revoked, and people are now in a desperate situation. Starting point: a fee waiver is an application whereby you are asking the Home Office to assist you with payment of fees because you cannot afford them, and you are making a human rights application. So the premise is making a fee waiver if you've got human rights grounds. But the challenge that happens for most skilled workers that have had their sponsor licenses revoked, their employer sponsor licenses revoked, is that some of them are not even intending to make on a human rights application, and thereby they are making in my own submission, an incorrect application. I know that lawyers, we don't agree on this point. People have got different views, different submissions that they make. But and again, on that point, some people have made fee waiver applications that have been successful, and they've gone on to make skilled worker visa applications, and they've been successful. Again, on the other hand, other people have had then to make skilled worker applications and refused because of the point that I'm going to raise now, the Section 3C point. Section 3C is under the Immigration Act of 1971, which says that if someone has submitted a valid application before their visa expired, then by operation of law, they are still legally in the country. Even when the Home Office have refused the visa application, but in time the person has made an application for an appeal and administrative review, then Section 3C is still operating. So fee waiver in itself is not a visa application. Some people believe that a fee waiver is a visa application. No, it's not a visa application. Fee waiver in itself does not give you Section 3C. But if you get a fee waiver, if you submit a fee waiver before your visa expires, and then if it is successful, you then make an application within the 10 days that they give you, then you preserve your Section 3C. If it's not successful and then you try again to make another fee waiver at some point, and then it will not be successful. This is in accordance with the recent case that came out in the Harbour Tribunal. So if you are going to make an application for a fee waiver, you will need to be very careful. Does it merit you having a fee waiver? Do you have other alternative routes that are available to you rather than a fee waiver? And if it's a desperate move that you have taken, as some people have done, before the fee waiver application has been done, or things like that, you have to reconsider whether or not it still gives you any advantage of continuing on the fee waiver application. Again, you need to seek legal advice. I'm aware people do advise each other, and I'm not or being disrespectful at all, and through WhatsApp groups and Facebook groups and so forth. But you need to talk to your lawyers who are well versed with these areas of law, particularly with immigration. So when you're making a fee waiver, you have to really consider your circumstances. Is it really the correct way to do it? Is it the correct route to do? Or you have to consider other routes that might be there. And sometimes the routes might include returning to your home country, making another application from there, and coming back. Again, each case is on a case-by-case basis. It's not the same for everyone. The other issue that I want to raise is about expert social worker reports. And this relates mainly to young children. Some of the cases that I have dealt with, or that we deal with, involve children that are outside the country, or even within the country. And most of the cases is about sole responsibility, where the other parent is in the UK, and the other parent presumably is outside the UK. And if they're outside the UK, are they still alive? Are they involved in the life of the child? What contributions do they make, and so forth? The confusions that are always there is about sole responsibility and sole custody. Sole custody is not sole responsibility. Sole responsibility is where you've got the ultimate decision-making rights upon the life of a child. You decide which school they go to, which church they go to, which doctor, which dentist who is going to stay with them, and so forth. You're in communication with these stakeholders that are involved in the life of your children or child, and you have to explain why. So the difficulty of explaining is that in other countries, the issue of culture and religion comes in. In terms of some cultures, even if the father is not involved, the child is given the surname of the father. In terms of other religions, even if he's not involved in a day-to-day or in the important decisions, when it comes to certain points in their lives, the father is involved and so forth. So the Home Office seems not to understand this, that for example, if it's a single parent who is a lady or a woman from certain cultures, they have to inform the father that they are taking the child out of the country, not necessarily because they're involved, but it's because of the culture and the beliefs If you don't do that, then this is going to happen to you spiritually, or this is going to happen to the child. Cases will come, or misfortunes will come, and so forth. So it's important to involve experts in these cases, whether it's going to be an expert social worker or an expert, a country expert who knows about the situation in that particular country. So we do work with a number of social workers globally, and also work with country experts who can explain why the person who is bringing the child really satisfied the requirements of sole responsibility, despite the minimal or no contribution of the other parent, who might be in the same country or outside, or deceased, or has remarried in their own home country. So it's important to consider these things as well. I know people sometimes do the court process of getting sole custody. Again, you need to be very careful how you need to do that. If the parent is involved in the granting you sole custody, then really they are making a decision of some sort there. You need to explain it, and explain it properly. So we are dealing with such cases where the Home Office is clearly misunderstanding the cultures, the religions of other people, and that someone has got sole responsibility, and we need to really strengthen our evidence by putting in everything, such as expert reports and any other report that might be there to show and cement that we have got sole responsibility of the child that is involved in the visa application. In addition to that, we might also have to consider the exceptional and compassionate circumstances that exist, looking into the living arrangements of the child, their medical, how it's affecting the child, how it's affecting the parent, etc. Again, if you require any advice, if you require any assistance, TAN Solicitors is there to help you. As I come to a conclusion, I just want to talk about something that is not in relation to immigration. This is about company house verification. Company house verification. If you are a director or a secretary or a person with significant control in a company, the company's house is requiring you to verify yourself. And these people are receiving emails. Please check your emails. And if you have not received emails, they might be going to whoever you've used to open the company for you. It could be your accountant or your lawyer or another agent that you've used. Make sure you verify yourself. You can verify yourself for free. You can be verified by an authorized company service provider, such as TAN Solicitors. At TAN Solicitors, if you cannot verify yourself, we can be able to help you to get verified by the company's house. We do charge a fee for that, but it takes away the responsibility for you to verify yourself. If you do not verify yourself, then there's a penalty that will be applicable, and you do not want to end up paying a penalty to the company's house. So thank you so much. My name is Andrew Nyamayaro. I'm a solicitor at TAN Solicitors. If you've got any questions that you want to ask or discuss, do not hesitate to get in touch. Our contact details are appearing there on your screen. We have got a team of lawyers in the office, so you might not necessarily talk to me directly because I might not be available, but there are some lawyers that are available in the office who will be able to help you. We have got a number of videos again available on our YouTube channel and on our Facebook page. Please follow us on Facebook and also subscribe, and on our YouTube channel, subscribe, take that bell so that you receive alerts, and then we'll be able to help you. Lots of information that is quite helpful on both our channels. Thank you so much.